Hey guys, this is our IP Pocket Talk. Know your rights as a copyright owner. If you see the symbol behind me, we see this symbol almost everywhere, like websites, books, movies, even YouTube's. You see this kind of symbol, and it stands for, yeah, that's right, copyright. So, what does it actually protect, and what right do you have? Today, we're going to have our legal advisor with us, Mr. Anthony Tay. Hi, Anthony. Can you show yourself?
Hi.
Yep. So Anthony is our expert in copyright prosecution in our firm. So whenever we see or we come out with things, our own work, we don't want people to copy it regardless. We just put the symbol there, right? C, saying that it's copyright reserved, copyright protected. So Anthony, what does this copyright actually protect?
A lot of the public actually has a lot of misconception about copyright. They tend to confuse between copyright and trademark. But the key thing which copyright protects is actually the expression of the idea itself. Expression. I will touch on it later on when we go dwell deep into what actually copyright curtails later on.
All right, that will leave it to you. Have you ever had this feeling like seeing your work elsewhere and say, hey, this is mine. This is my work. Why is it there? Like, what can I do about it? If you've had this feeling before, you've come to the right place. You're especially at the right place joining our talk for today. So without further ado, let us proceed with our agenda. So Anthony, let's begin.
Oh, all right. Hello, everyone. I see the attendees is not really that many of us here, so I will try to keep this as simple, as straightforward, and least confusing as possible. Majority of the talk today, I will touch on copyrights, and I will also give some updates in regards to the recent update of our Malaysian Copyright Act, where there's an amendment recently last year, and it will come into effect very soon in regards to the new law. And also there are also some changes in regards to the procedure-wise, which already take effect on the 18th of March, which is this month, very recently. There's a procedure change in terms of copyright registration. I will use the word registration here, but please don't be alarmed of the registration here, but I will go through what is actually between the word registration and notification to the registry. There's a big difference there and here and there. So I will try to be as fast as possible without wasting anybody's time because it's a working day. So I will keep it, even though the talk was stated is about 45 minutes, but I will try to maintain it within a half an hour to 30 minutes, and everybody will have a better idea in terms of what copyright actually is. So allow me to share my screen. Okay. All right. Devices. All right. First, know your right as a copyright. So what are the key rights and what does it cover? So in terms of copyright, because copyright itself in Malaysia is not really that developed of a law in comparison to some Western countries where copyright, there's a need and there's a requirement for you to register your copyright before you could actually enforce it. The Western has actually have a more thorough and more comprehensive protection in terms of copyright in comparison to Malaysia. But that doesn't mean that Malaysia do not have any protection whatsoever. As a member of the Berne Convention, we do copyright copyrightable works of an author as long as it is original. So I'll first need a brief recap on what actually copyright is and what does it protect here in Malaysia. So in terms of copyright, there are actually four main limbs of copyrightable works, and those are the artistic, the literary, the musical, and the dramatic works. So in Malaysia, we do have a certain we do branch up few of the based on these four limbs, which is we do have sound recording, broadcasting, and all those entrepreneurial work, which has a fixed lifeline to them. If the four main limbs you see here on screen, actually has a very long lifespan. So the moment the copyright is born or being created by the author, it will enjoy a lifetime of protection at the moment it created and last an additional 50 years upon the author's death. So these are the four main limbs of these are the lifeline for all the four limbs of the copyrightable works you see on screen. Whereas for entrepreneurial work, which you do in Malaysia, actually provide them and actually only a fixed 25 years of lifespan upon creation. And this is actually for those broadcasting and sound recording, all those are only lasted for 25 years upon creation in comparison to the four main limbs of the copyrightable works, we enjoy a significantly longer lifespan, as you see on screen. So the requirement for copyright to be actually to be recognized as a copyrightable work, you only need to be original, which is created originally by you and produced in physical form by a qualified person. Please don't bear too much attention to the word qualified person. The qualified person here under the Act actually means that you are a resident of Malaysia, and that's about it. So prior to, in my introduction, I actually mentioned registration of the copyrightable work, but what actually registration here in Malaysia actually means. As I have touched on the Western country, registration actually means there's a need to register it before you can enforce it. And that is true for certain parts of the world. Like, for example, in the USA, you need to register your copyright before you could actually enforce it or sue someone for infringement of a copyright. Hence, there's a very extensive set of law in the Western country. But here in Malaysia, we do not have such a requirement for you to enforce your copyright. So hence pose the question, is it better for you to register or notify the authority? The authority here means the Malaysian Intellectual Property Organization. So is it better to notify the authority for your work? We'll go through it one by one. So what are the main benefits of having your work notified to the government? So the first and the most important benefit here is the government is being notified. There is an advantage in the notifying the government, whereby the government, in exchange for your voluntary notification, you will be given a certificate. So the certificate actually provides you ease of enforcement, as you can see in point number 4 there. It's actually served as a prima facie evidence, whereby it is very hard to rebut. But of course, it can be challenged if, let's say, someone is suspected of the originality of the work or suspect the ownership of the work. It could be challenged, but it's actually a prima facie evidence the moment you produce it in court. You mean basically you need not prove otherwise that the genuine of the certificate itself, because it's granted by the government. If you can see in point number 2, it's actually reduced dispute. It's actually a very good benefit for, especially among co-authors, or there's more than 2 authors involved in a particular work. Because during the registration of copyright, you need to state the ownership of the copyright. And back before the law was changed, the procedure was changed, the author you need to name every single author in the application itself. But after the 18th of March, the author is no longer required to be filled in the application form. But in the sense that the owner itself, you still need to say how many owner itself to own the actual copyright of the work itself. So it is actually a good way to reduce dispute among co-owners. Presume in the assumption there's no agreement existed between the owners. And also, there's one good thing about the copyright. Once it's registered or notified to the registry, there is no renewal needed, meaning there's no maintenance involved. Unlike trademarks and patents, you need to renew in a certain period of time. So these are the main benefits. Of course, you also need to know about the downside of not registering. So the downside is that there is a need for you to maintain a record of creation, because copyrighted work, yes, it is undeniable. It's an automatical right. It arises the moment it comes into material form. Basically, for example, let's say I write a book. The moment I write a book, I save it and print it out. That's my work, and it's enjoy protections under the Copyright Act. So, however, how do you prove the date of creation is the problem here? Because without a certificate which mentioned the date of creation, the date of publication, and who owns the mark, without this government certified certificate, you need to maintain a strict track record of all the evidence you have prior to the creation of the work itself. So it is a hassle to maintain a record, and physical records do decompose over a certain period of time. As I mentioned, the protection actually lasted throughout the life of the author, so it is a very difficult thing to maintain. Of course, generation change and technology itself is involved, so of course maintaining records will be at ease, but it is also a bit of hassle if you want to trace back all the track records or the records that whereby you could have misplaced over the years. And also in terms of proving to the authority, if the moment you want to enforce it, without a certificate, you just throw a certificate at the relevant authority and they will just do their job. Rather, in comparison to how are you going to prove your ownership, you actually own the copyright, and that particular third person is actually infringing your copyright. How are you going to prove? How are you going to tell or explain to the authority to assist you to enforce your rights? So this is one of the downsides in registering in comparison to the one of the owner who have registered, who have notified their work with the authority. And the last but not least, you have the need to defend against challenges from infringer. For example, if you don't have a cert, although the cert could minimize the challenges from infringer to a very, very bare minimum, but let's think about this situation where you don't have a certificate and you issue a C&D letter or a takedown notices to any infringer or any platforms online, requesting them to take down the whatever work you are claiming that you have owned a copyright upon. But you could face a challenge from the infringer. They could saying that, say, this work is actually owned by me. I created it out of my own thinking, out of my own idea. What makes you so sure it belongs to you? So without all of this certificate or all of this documentation to prove, you could face a lot of challenges amongst the way during your enforcement. So these are so I will let you all as copyright owner to think and gauge whether there is a need to notify the authority after I'm going through this. Before I go on to the slide, for those who have any questions or later there will be a Q&A session, so you may think or type it out now in the comment section, and I will go through the comment section later on to answer each and every one of the questions there. To save everyone's time, you need not wait until the end of the session before you type out your question. You could type it along the way as the presentation go on. So what are your rights as an owner of a copyright? So your rights is an exclusive right over the material you own, including the followings: reproduction of the work, publicizing or publishing of the work, communicating or corresponding. The communicating and corresponding here is by meaning that you send an email or you send a messenger text. All those are considered communicating or corresponding, or even you upload to a particular platform. And public performance, these are mainly involved for dramatic and musical work. Adaptation here meaning that you adapt a particular work and transform it into a new work itself. There is another word for it. It's called the derivative work. The derivative work, if not used or not performed or not executed by the owner, is a form of infringement. So do bear in mind. Do not have a misconception whereby I have used a reference from this particular work, which you do not know whether it's still the copyright is still valid or not, but you adapt it from that, or you may use it as a reference and created your own work. That new work itself could be an act of infringement. So do bear in mind. As well as broadcasting, you do have as an owner, you do have the right to broadcast it. So here are your basic rights as a copyright owner. Okay, before I will delve on the remaining parts of the copyrights, what needs to be aware of, I will have to go through in terms of public domain. And a lot of people has a misconception whereby they think that any material or any work uploaded on the internet is automatically public domain. But that is not entirely true. Yes, there is certain things on the internet which are free to use and are copyright free, but you do have to bear in mind not every single images or not every single notes or works or music uploaded to the internet is actually yours to use. It is not actually, even though it's fixed or uploaded to a public space, but it's not actually means that the work has entered public domain. So what actually is public domain? Public domain means works which are free, not if not protected otherwise by other parts or limbs of the intellectual property. So essentially, public works which enter public domain range an expired work. For example, the author has died, has passed away for more than 50 years, or in certain countries 70 or even 90 years, and that work will be declared entered public domain, and everybody is free to use the work, including readapting it or creating based on it as a reference to create every single work of it. Of course, their work itself, if you said another thing about it is that there's no physical presence of the particular work, i.e. it's just an idea. Like I said earlier on when I was answering Marcus' question, copyright protects an expression of the idea, but not the idea itself. So let's say the particular thing or the particular idea itself is there, and it's mentioned there that says, let's say, for example, that a particular writer writes an idea about certain, for example, a concept or a methodology about ways how things should run in between the movies, or even how things should have been done in a dramatical work or like a Broadway performance. All those are just an idea, but it has not been materialized into an actual work. That itself is actually considered as a public domain material which the public could use. And the last but not least thing is the non-original work. Basically, it's a readaptation of another one or another original work. So it's a non-original work, or basically it's a very common idea which everybody has been using it now. So that is a non-original work. Everybody can be used. Here are some examples for what is actually a public domain work itself. Official, legislature, or government documents, basically all those government announcements. You are free to share and copy and paste every single thing and post it however you like, because those are not copyrighted works and those are in the public domain itself. Book or movie titles, those are the public domain. Those are things which are in the public domain which you can use. But do bear in mind, when I mention books and movie titles, it's not on the content itself. The content of these are actually copyrightable works, but the movie titles and book titles, all those could be protected under trademark, but not necessary. But it's not a work it's by itself. It's just a basic idea. So it could be protected under limits of the intellectual property. And you have seen on the third bullet point is on procedure, methodology, and system. All of these are basically just laid out on whatever thing which is on the explanation on the procedure, the methodology, and system itself, or process, or technology. All these are not copyrightable. It could be protected under patents, however, so it's a different story. Okay, so as I mentioned earlier, our materials on the internet considered free to use. Of course, it's not entirely free for you to use, even though you do not use it for your own commercial benefit. But the moment you use someone else's copyrightable work and you repost it or republish it somewhere else, even though you are not doing it for some commercial gain, you do indirectly infringe upon another's copyrightable work, which is a bad thing in a sense. So how to protect your work when copyright can no longer be used? For example, I don't know anybody heard about a recent news that Winnie the Pooh has entered the public domain on 1st of January this year. This is a book, Winnie the Pooh is a book first published on 14th of October 1926. So I believe everybody will have a misconception. Yay, Winnie the Pooh, I can use however I want on the Winnie the Pooh thing. But sorry to break if I break anyone's bubbles. Winnie the Pooh excel when they mention enter public domain. It's not in terms of the bear in the red shirt, the yellow bear with the red shirt. It's not the icon itself, but it's on the content of the book itself. So if anybody would like to, for example, author or even novelist or journalist would like to use the content of the 1926 book, they are free to do so, but not in terms of the iconic Pooh Bear. So how do you protect something when it has entered public domain? As you can see on screen, the word Winnie the Pooh is actually a registered trademark here in Malaysia. So of course, Disney would not be so dumb into the moment it's entered public domain, I will allow anyone to use my character or my animated characters. So they have registered it, the word Winnie the Pooh, across a lot of classification here in Malaysia, including the single word Pooh or even the word Winnie. They have registered it. So basically, do not be misconstrued when we say that certain things are entered public domain. Mickey Mouse, the original Mickey Mouse, has also entered public domain. Now it's time for Winnie the Pooh has also entered public domain. But the only thing you could use or free to use for Winnie the Pooh is a book. which has been published, first published in 1926, the book itself and the content of the book itself, not the bear itself. So do bear this in mind. So here I have an exercise for you all to think about, which I have observed from clients, which actually has inquired about someone else copied their copyright work, and they intend to sue for damages the moment they use the content or the work itself. Here are two images which I have extracted from IKEA, Malaysia, whereby, for example, just treat this as not a photograph from IKEA. So the one on the left is actually a copyrightable work. Yes, it's a photograph, it's an image. And for example, I am as an owner, I've noticed someone else has used the photograph on the right to sell the chair in the photograph itself. So I would like to ask everyone, let me open the chat room. Let's see, anyone here is, yes. So I will answer this later on. I saw some question here. Okay, so anybody on the, let's say I'm an owner, I saw someone else's use selling the chair on Shopee or Lazada or wherever platform there is. So am I as a copyright owner, can I sue the particular infringer for the chair he used in the photographs on the right? If your answer is yes, then you may put the number 1 on screen. If your other answer is no, just remain silent. I'll give you 5 seconds as I take a sip of tea. Okay, so I see someone. Okay, as I mentioned, if you think you are able to sue for copyright, I have to break it out to you. The answer is no. You cannot sue someone else from just using a part of the chair because, as I mentioned, the copyright protects an expression of the idea. So the photograph itself is a copyrightable work. If you want to sue someone else for infringing your copyright, that photograph itself, yes, the chair is there, but it's only one part and parcel of an original work. So let's say if the entire image has been used, posted on his platform, Shopee, Lazada, or whatever, you are able to sue him for copyright infringement as he has mainly copied and pasted your photographs upon the website. But if let's say he has used a similar chair, and the chair is basically just a reference, which I have amended it like upside down. Just assume that the images on the right is taken by on its own, is selling the chair. That itself is not a copyright infringement. But you may potentially sue him for industrial design infringement because the chair itself, the product itself is protected under design, but not under copyright. You can only sue someone for copyright when the entire image, or let's say the substantial part of the image, has been copied. That itself you can sue, but not only part or one of the element has been used. So this is a very common misconception where the public has been a particular client has thought of. The moment I see some elements of my photographs or the product in my photograph has been copied, I can sue him for copyright infringement. As I mentioned, the copyright only protects the expression and the entire image itself, not the individual elements in the product, in the image itself. So you have to bear in mind, if you want to sue him for copy or selling your chair, if the chair is protected under industrial design, then by all means sue him for the industrial design infringement, but definitely not copyright infringement unless he used the entire image. So I hope I cleared a lot of misconception here in the public. Okay, let's continue. I see a lot of questions here. I will answer later on, yeah? Yes, okay. So I will give a rough summary in terms of what I said earlier, okay? So expired work may be protected by a trademark or other limits of the intellectual property. So for example, if let's say the name is very distinctive, you can protect it under trademarks, or the design of a particular product itself is very, very unique, you can protect it under design, not necessarily under copyright. So expired work may be readapted into new work to enjoy subsequent protection. This is actually I did not mention earlier on. For example, For example, let's say back to the Winnie the Pooh issue. The book itself has entered public domain, but Disney could actually readapt the entire storyline, create it into a new storyline, for example, a sequel or a prequel, like a recent trend, they like to tend to go prequel. He could write a new thing. The book itself well, the moment it materializes, it enjoys a further lifeline of the author plus 50 years upon death or upon creation. That is how you protect a work which has entered the public domain. You could readapt it into a new work which enjoys subsequent protection of the derived work, which I said here, derivative work. Also, work which is protected by patents, this I mentioned earlier on, which is protected by patent, cannot be enforced by a copyright. Because industrial design is also known as a design pattern in the rest of the world, so I will just mainly use the word patent here. If the work is protected by patent, it cannot be enforced by a copyright here. It is also expressly stated in our Malaysia Copyright Act. So do bear in mind and have a weight between whether you want to protect a particular work by a copyright, by snapping an image of it, or you want to protect it by a design, which is a more comprehensive protection in comparison to copyright for certain parts of the work or certain product itself. So there is a clear definition between these two types of intellectual property. Okay, here are some food for thought. So before I go in, there's a true or false question here, which I think a majority of the public would actually confuse between the symbols, for example, or how which also a rough guideline or whatever, or a rough summary of whatever I just mentioned earlier. So I will not ask the public due to time constraint, I will not ask the public to answer one by one. So I will just go through it very swiftly. Okay, first thing is the C symbol is not there, hence it is not copyrighted. Is it true or false? So the answer for this is false. Even though the C symbol is not there, it doesn't exclude its right as a copyrighted work. So do bear in mind, the use of a C symbol is a matter of choice, but it's not a matter of requirement, unlike even trademarks. With the moment you register it, the R in circle is a matter of choice. It's not a matter of requirement under the law. So do bear in mind. The second thing is I do not charge a fee for it, so I'm not infringing anyone. I believe I have answered this earlier on during my presentation. Even though you do not charge a fee for whatever thing you are doing or whatever thing you have copied, it is indisputable that you are still using another one's work. Hence, you are still infringing another people's work. So hence this statement is also false. So the third thing, if it is posted on the internet, then it is in the public domain. I believe this is a very simple question. It's a false thing to do, which is a false statement. Not everything posted on the internet are free to use. End of story. Okay. The fourth thing is, it's a true statement. No one could ever steal my work even if I do not defend it. Yes, it is correct. As I said, copyright is an automatic right which arises the moment it's being created. Unlike patents and trademarks, there are still a chance where it could be stolen or could be stolen by someone if you do not defend it. Trademarks, I exclude those countries which practice the thought of passing off, where you could still reclaim your rights even though you do not defend it. But for patents, the moment you do not file it and someone else uses it, you are not able to defend it, because patents only has a right upon registration. If you do not register it, you do not have the rights. So, but unlike copyright is, and you enjoy your rights no matter however you don't even want it, it is still yours, even you do not want it. So it is still yours even if you don't defend it. So it is a true statement. The fifth one is, I'm inspired by another to create something on my own, and therefore my new work belongs to me. Yes, you could say that it belongs to you, but the statement is false if you pay close attention to whatever I have said earlier. This actually belongs to a derivative work. The derivative work could be a form of infringement if the work you have referred is still valid under copyright and the author or the owner itself is still alive. So this you need to be aware of. And the second to last statement is, violation of copyright is a crime. I believe everybody will know this is true. If you go to the movies, before you enter into the main climax or the main content of the movie session, you will see a copyright statement big and wide on the screen. Copyright infringement is a crime. You could be fined, it could be jail or both. So it is actually true. So violation of copyright is a crime. And in our new law, they actually added a new I would say is a welcoming change to copyright law, which they include certain things I will go through it later. So violation of copyright is definitely a crime. This also includes all those selling DVDs and CDs and whatnot on the roadside if it's still ongoing now. Okay. The last statement is owner would love it since I advertise their work for free. Yes, you advertise their work for free, but have you asked the owner whether they mind you simply post it, simply repost it, or simply tweet it without their consent? Not every single owner is as open-minded as certain big brands where they do not mind that, oh, it's a free advertising, they do not mind, but it doesn't exclude the fact that you are still infringing their rights. Okay, so the statement is false. So I hope this food for your mind has opened certain, this actually has been shared during last year in my first session on copyright, but I just thought that this is so good, I might as well share it one more time for those who did not attended my first session. So I believe this is the second last part of my presentation. Oh my goodness, the time is running short. Okay, so what are the effective ways to enforce your rights?
Yes,
Very short part because copyright enforcement. Did I hear something?
Yeah, the time is running short.
Steps for you to effectively enforce your copyright works here in Malaysia, which a lot of owners do not know how to do other than sending letters. So the first thing you absolutely must ensure is to determine the infringing activity. Yes, I know they say what is so complicated about determining infringing activity. Yes, I have to break it out to you. Determining an infringing activity and not only applies to copyright, but also applies to every single part of the intellectual property. Because you do not want a false claim on your hands. The moment you have a false claim on your hand, there's a very, very major repercussion, not only in terms of your face, but it also adversely affects if the matter has been escalated to a court setting. You could get an adverse cost order. You could also bear and lose, then you have to pay back whatever you have claimed towards the infringer, where there's a potentially for countersuit or unlawful interference. So these all you need to determine. And for copyright wise, there is a need to consider whether the infringing activity falls under the fair dealings exception. Fair dealings exception here refers to the use of work merely for academic purposes. For example, I have used the Winnie the Pooh image here in my session. Yes, I am actually infringing Disney work because I have copy and pasted and published it and show it to you all. I have used the Winnie the Pooh logo, but it falls under fair dealings because I'm doing it, I'm doing for free, and I'm also doing for the purpose of education. So I'm educating the public here. What am I doing and trying to give everybody a bright idea on copyright? So my action here falls under the exception of fair dealings. So you have to be properly advised or properly ensure what the activity is before you actually proceed to your second step, which is determine the identity of the infringer. So the identity of the infringer in the current generation is very hard to determine the identity of the infringer. Certain people will hide behind a proxy, or certain people will hide behind a company, and there's a few layers of company you have to go through. But in this certain situation, you cannot, of course, if let's say the matters happen on Lazada or Shopee, you could always use their platform to do whatever thing. But if you want to be strict, you want to hit the infringer on the mark, you first need to determine the identity of the infringer. And the online platform would not be so cooperative in giving you the identity due to the Data Protection Act. So they're not at liberty to disclose it to you. So in such circumstances, you could appoint a private investigator to investigate the identity of the infringer before you need to point out the correct infringer, before you intend to sue or take action against. So step 3 or step 3A, there is two ways you could enforce your copyright. One is to lodge a complaint to the KPD and HEP, which is the Ministry of Consumerism. You could lodge the complaint. This is where your certificate could be very useful here in these circumstances, because the officer there will only want to see a cert, not your explanation. The moment you have a cert and provide the details of the infringer, then they will do their work for you without you having to go and explain lots of police report and bring the police report to the to the ministry and explain to your heart's content until they don't understand whatever are you say talking about. So here is where cert would be very much useful if you want to go to the ministry rather than resort to the litigation part. And of course, there's also a 3A. You will appoint a counsel to serve a takedown notice to the infringer. For example, if, let's say if the thing happens on Shopee or Lazada, they do a separate channel where you could click on and lodge the complaint there. And if you, the moment you give them a cert of copyright, they will immediately take down within 7 days. Trust me, I have done this before. They do act quickly in terms of intellectual property. So they do act very quickly, but they need a cert though, okay? And the last resort is definitely litigation. Even as a legal practitioner, I would not advise you to go to lengthy and costly litigation before you resort all the out of court settlement or out of court resolution. These are all very, very easygoing or straightforward proceeding before you actually want to resort to a litigation. I know a lot of people would like to say, I want to sue him, I want to sue him. It sounds very fun when they say I want to sue him. But the process behind the word suing is a very hassle and it's a very costly way, and not every single client of ours understood the process on the court setting. So it's very hard and tiring for the client itself as well as for the advisor itself to advise on the client in terms of the litigation process. So litigation is definitely a last resort. So I will go through this quickly. 3 things to look at, okay, for determining infringing activity and infringement. So we do have a case law here in Malaysia whereby they have stated that the 3 things to look at in determining whether a particular work has infringed a copyright is to objectively look at the similarity. So the moment you see two work comparing side by side, but a reasonable person would think that, oh yeah, it's very obvious, it's copy. So there's an objective similarity there. And of course, there must be a causal connection. The causal connection is that you need to see that there is a link between the first work and the second work, and not only simply just because you think that, oh, I think he's copying from me, because look, I can see traces of it. So you cannot simply adduce a statement like that. You need to actually show a causal connection between the two work, and the part infringed form a substantial part of the original work. These are the 3 things you should look at when you're determining whether the work itself, whether it's infringing or work. All right. Of course, as I mentioned already, we need to determine whether activity falls under fair links. And also, information obtained from social media should be further verified, as I mentioned earlier. Actually gone past this slide just now. All right. Okay, 3A, and I also explain it too, and you can have a look through, you can have a say, you can compare to the copy DNHP, and there is a consider court method already made available to government authority, because copyright infringement is both a crime and a civil liability. So all these 3 points I have explained in the first slide during this part. So I believe this slide will be sent to the participant later on, but I will of course remove all those infringing materials. Okay. I had mentioned earlier on during my first introduction that there is actually a landmark case happened last year whereby the High Court, the IP courts of Malaysia in the High Court has actually delivered a decision whereby distribution and supply of TV box or illicit streaming devices ISD that provide unauthorized access to copyrighted works, for example Netflix, constitute copyright infringement under our Act. So even though the Act previously was silent in terms of online activity, but the court actually construed our Act into believing that even though you have it's an online activity, has no physical presence, but this activity is a form of copyright infringement under our Act. So let's say if anybody here in the audience is selling TV boxes, please bear in mind you are at risk of of crime. Okay. The action is actually brought by Astro, actually by Miasat Broadcast Networks in Berhad. So it's a provider for Astro, and the action was taken against a seller in ICT. ICT, I believe, is in Klang. So against ICT. So the company actually found guilty under the Copyright Act, and therefore has been convicted of crime. So do bear in mind, this is a landmark case for digital piracy. The introduction of that particular case law, I believe, is the trigger which triggered the amendment of the current Copyright Act. So they have introduced the punishment for offenses related to streaming technology. So even though during that he was convicted, but there is no clear guideline for the court how to punish this sort of offenses. So the new amendment will include how to punish these offenders. So the offenders could be fined of no less than 10,000 ringgit or no more than 200,000 ringgit or a maximum of 20 years imprisonment or both. As you can see, it's a very, very serious punishment for illegal online streaming merchandises or services. So those who doing this kind of services better watch their back from after this amendment has taken into effect. All right, I believe that's it. Let me go through the question and see what I can answer here. We are right on time with 5 minutes left. Let me go through the, can you elaborate? The first question is from Mr. Razid Muhammad. Can you elaborate on Creative Commons works and how do we use them? Okay, how do I copyright my own musical composition to register? All right, okay. Mr. Razid, I believe actually I'm not really sure what does your Creative Commons works mean, but if let's say I would say that you are a musician, so the moment because musical works actually consist of several limbs, because the musical notes which you compose, you write as musical notes, that is considered as a literary work, which is one of the work. The rhythm of itself is also another work, and the performance you perform is also another type of dramatic work. So you do own the work of the entire music composition which you have created. Of course, there is you do need to register it, as I shared earlier on. There is a lot of benefit. Did you say something? There is a need, of course. There is a lot of benefit the moment you register your copyright. But as I said, it is automatically right arise. But for musicians and artists such as yourself, I advise you to look for a licensing body, because the new act has actually unified all the licensing body into one, so that you could delegate the enforcement rights to this licensing body, which could assist you in collecting royalties and help you to monitor the public whether there's any infringement towards your musical work. So of course, if you ask me whether there's a need to register, of course, I will welcome you to register it. But even you don't register it, you are still able to protect it. You are still able to get the protection, the rightful protection under our act. So this you need not be worried about. Okay, from Mr. Razin, what about the material use needs to copyright? The material use, I believe here are you referring to the required documents? It's actually very simple. You just need your name and IC and the work itself. So for example, if you want to register your music rights, we only would assist you to register, to help you register your music note composition. The one that the one with the line D and the notes thing, we will help you to register that or notify the registry that this is a musical work created by you. So, and owned by you. So we will help you register it. These are only the materials you need, which is very straightforward. The new law actually abolished the need for a statutory declaration. So it's a very straightforward process now. Accelerate here. Okay, so what if a composer copyrights his work a few years after the rearranged original music work? Is this a self-infringement? Oh no, definitely you can't self-infringe yourself. As I said, the owner itself has the right to adapt the work itself. If you are the owner and you have created or rearranged the original work, of course, the new work is actually a new copyrighted, a derivative work referred as referring from the original work. Of course, there's no infringement per se here, because you yourself as an owner has created new work. The situation will be different if you authorize another one, or you have appointed or another singer or another artist has rearranged your composition without your consent. Of course, it is an infringement. Time's up. All right, I believe that's our question. Oh, okay, you're welcome. Any question from the floor? I believe Marcus, you can take over. I'm thirsty.
All right, thank you very much, Anthony, for your thoughtful sharing and for answering Razif's 3 questions. So because of time constraint, we're going to end the talks. If you have any question, please feel free to... Yep, exactly. Please feel free to text us by putting down your comments in our Facebook page, yeah? And so
let me end the share first.
Yeah.
Let me end the share, all right.
To wrap things up, yeah, so if I understand correctly, or if I'm mistaken, please correct me, yeah? So in Malaysia, most of the copyright is auto protection, but it's better to register them so that you have a proof of tangible ownership of your work. Am I right? Yeah,
Yeah,
and
correct,
not everything you take from the internet is free to use. Not all is in
Yes,
the public domain. And we can actually file complaints to the consumer department or serve a notice, or in the worst case scenario, sue if you find anyone infringing your work.
Those
Yeah.
stubborn infringer.
Yeah. So that summarizes our talk for today. So if anyone has any question, we can take one more last question. Okay, no more. Right. Thank you
I believe it's
everyone
very
for
straightforward.
joining our talk for today. So please like and follow our page if you want to follow more talks in the future. Yeah. Thank you everyone for joining.